8 months after Air India 171 crash and amid mounting questions as to what brought down the 787 Boeing, a fresh controversy has erupted. Lawyers representing 130 families preparing class action suit against Boeing allege that victims are being pressurized to give up their right to sue major corporations as part of the final settlement with Air India. It is not unusual for airline to ask legal indemnity for itself after a crash while settling compensation. What has raised eyebrows, however, is the reported clause requiring families to waive their rights to pursue litigation not just against Air India but other powerful entities. These include Boeing, the aircraft manufacturer, GE Aerospace, which makes the 787's engines, Honeywell, provider of avionics and critical systems, Safran, manufacturer of landing gear, and even the Union of India, including the Ministry of Civil Aviation and Ahmedabad International Airport Limited. We spoke to one of the victims whose 3 family members were injured, not on the aircraft, but on the ground at BJ Medical Hospital. On conditions of anonymity, he told us.
4 महीने पहले मेरे को ये लेटर आया ना, उस टाइम I was busy with my examination. उस टाइम मैंने सोचा ये रूटीन प्रोसेस है, ये सब लोग कर रहे हैं, इसलिए मैंने करके भेजा. उसका बाद मेरे को पता चला ये इट इज नॉट ए good way to deal the people who was injured during the flight accidents. I come to know it is 2 days back when I talked with some other person. That's why I have some regret.
In response to questions from Mojo Story, the spokesperson of Air India told us, families agreeing to receive final compensation are requested to confirm that they have no future claims against Air India or anyone else, including original equipment manufacturers, airport, government agencies. This particular aspect is important in order to ensure that the process is indeed final and to prevent Air India from receiving any direct or indirect claims in the future. We have been transparent in our communication to families, including seeking legal advice before taking a final decision. Air India also says it has followed recognized industry standards, adding that the amounts offered to each family have been calculated using the applicable legal framework and differs depending upon individual circumstances. Officials in Air India speaking on background argue that the case against Boeing or any other corporation in America would invariably make the airline to party to the dispute. But Ayush Dubey, working on the class action case against Boeing, counters Air India. We oppose this document. It asks grieving families to surrender all legal rights while the investigation is incomplete. Most troubling, he alleges, the airline appears to be shielding manufacturers and blocking families from pursuing claims in more favorable jurisdictions. After the crash, Air India announced an interim compensation of 25 lakh to all the families who died. The Tata Group pledged an additional 1 crore per affected family. But it is the conditionality attached to the final settlement, especially the reference to Boeing. In the aftermath of the tragedy, sections of Western media blamed AI-171's pilot Captain Sumit Sabharwal. His family and the pilot community strongly rejected those claims, pointing instead to a documented history of technical concerns surrounding the Boeing 787. As questions continue over the safety of the aircraft and investigation into the crash is before India's Supreme Court, critics are asking, why should Air India settlement require families to waive claims against Boeing and other manufacturers at all?